My name is Lauren Burke. I am an attorney with Judicial Watch Incorporated. Several years ago, Judicial Watch, as part of its mission, started submitting routine travel request records for what we call VIP travel, which is essentially the first families. Since 2015, we've made 75 or 80 travel requests. The Secret Service, it has seemed, we allege, or what we call a pattern or practice. They acknowledge receipt of the request, and then they sit mute, unless and until we file litigation. Judicial Watch versus Department of Homeland Security is a litigation that we brought in federal district court for the District of Columbia. We alleged the Department of Homeland Security, specifically the Secret Service, seemed to have a pattern or practice or procedure of delaying responses to FOIA requests that Judicial Watch would routinely make unless and until litigation was filed. Congress enacted the Freedom of Information Act, or FOIA, which is the statute that is at issue here, and in doing so, implemented some very clear requirements for agencies to provide the American people with open government, with some transparency. The public has a right to open records. They make a request, and an agency has 20 days to make a determination and inform the requester of that determination of whether or not the agency will make available the records that were requested. The agency was relying on that judicial recourse available to a requester before they made any move to fulfill their obligation under the statute. That was not the intent of Congress. That is a violation, clear violation of the statute. If such an interpretation were tenable, then it would render the statute and Congress's inclusion of timeframes and procedures and requirements as essentially dead letter. There would be no point to it. The agency essentially is flaunting FOIA by disregarding its obligations as Congress put on them. They are public servants, and they have an obligation to fulfill the requirements of FOIA and respond to requests in a timely manner, make a determination and inform the requester, and then produce records promptly. And that's what the Court of Appeals found. The court has made a strong statement to agencies. You have an obligation, you need to fulfill it.